Living trust versus will. What's the difference and which is right for you? Choosing between a living trust and a will is an important decision when planning your estate. Both tools help distribute your assets after you pass away, but they serve different purposes and offer unique benefits. Understanding these differences can help you make the right choice for your specific situation. Legalities of living trusts and wills. Both living trusts and wills are recognized under New York law as legal instruments for estate planning. A will takes effect after death and must go through probate, a legal process overseen by the court to validate the will and distribute assets accordingly. This process can be time-consuming and public. A living trust, on the other hand, becomes active as soon as it is created and funded. Assets in a living trust avoid probate, ensuring a quicker and more private transfer to your beneficiaries. New York law requires that a trust be properly funded and managed to be effective. A lawyer can help ensure all legal requirements are met and assets are correctly titled to avoid complications. For both documents, it's essential to meet legal standards such as proper execution with witnesses and, in the case of a trust, appointing a trustee to manage the trust. An attorney can guide you through these requirements to ensure your estate plan is legally sound. How to decide between a living trust and a will. Choosing between a living trust and a will depends on your estate planning goals, the complexity of your assets, and personal preferences. Privacy concerns. If you value privacy, a living trust is preferable, as it avoids probate. A will, by contrast, becomes part of the public record during probate. Asset management. For ongoing management of assets, especially in the case of incapacity, a living trust provides a seamless solution. A will does not address incapacity and requires additional legal documents, such as a power of attorney, to handle financial matters if you are unable to do so. Cost considerations. Setting up a living trust may involve higher upfront costs due to legal fees and administrative expenses, but it can save money on probate fees later. Wills are generally less expensive to create but may incur higher costs during the probate process. Simplicity. If your estate is straightforward, a will might be sufficient. However, a trust is better suited for complex estates or special circumstances, like providing for a minor or a loved one with special needs. Working with a law firm ensures your unique needs are addressed, and a lawyer can explain which option aligns best with your financial and family situation. What is the process of creating a living trust or will? The process of creating a living trust involves drafting the trust document, appointing a trustee, and transferring ownership of your assets into the trust. This step is critical to ensuring the trust functions properly. An attorney can help with the preparation and funding of the trust to ensure compliance with state laws. For a will, the process is generally more straightforward. You will need to name an executor who will manage the distribution of your assets, designate beneficiaries, and specify how your property should be distributed. Like trusts, wills must meet legal standards, including signing in the presence of witnesses. Both processes require careful attention to detail, and a qualified law firm can ensure your documents are comprehensive and enforceable. Properly executed estate plans provide peace of mind and help prevent disputes among your loved ones. Planning your estate is a significant step in protecting your legacy and providing for your family. New York legacy lawyers can help you navigate these decisions and create a customized plan that meets your needs. Call us today at 718-713-8080 or visit us at 132 32nd Street, number 301, Brooklyn, New York, 11232 for experienced guidance in your estate planning journey.